Hello everyone, warm welcome to this video series. We are looking at addressing the dispute resolution challenges of Japanese companies doing business in ASEAN. So this is jointly produced by the ASEAN Japan Center, the Singapore International Arbitration Center, and the Singapore International Mediation Center. So I'm Chuan Wee Meng, CEO of SIMC. Thank you for joining us today. For this episode, we are looking at beyond COVID-19, doing business and resolving disputes in a post-pandemic world. I'm very, very pleased to have with us Mr. Bazul Ashhab from Bazul and Ms. Jelita Pandjaitan from Linklaters. What are the trends in dispute resolution in light of COVID-19? What have we learned? What do we need to unlearn from this experience with respect to dispute resolution?
So I think we all imagined, Wee Meng, that at the beginning of COVID there would be a huge explosion of disputes and collapses of companies, a little bit like what we saw in the global financial crisis back in 2008. For those of us, I think all three of us are old enough to have been around in that time. And it was a time of huge activity in the disputes environment. But on this occasion, I don't think we saw quite the same approach from companies. And there are a couple of reasons for that. Companies were prepared to negotiate or to forbear in relation to problems on the other side, failures of performance. There was perhaps more indulgence around that, or maybe renegotiation of obligations. And I think parties were really concerned that the other side would collapse while they were trying to recover their money or sue for damages, this kind of thing. Everybody understood they were in a similar situation. So we saw more patience, I think. And then that flowed through to the mechanisms that people use to deal with their arising disputes. And I think we've learned a lot about the process of dispute resolution in this period, as we have in almost every other aspect of our lives, in relation to how to negotiate, perhaps also pick up options for mediation or other ways through these sorts of situations.
So the pandemic has brought a sharp focus on destructive litigation and constructive litigation. Destructive leads to bankruptcy, constructive leads to recovery and a win-win solution. Mediation allows you that win-win solution. And I have seen a sharp increase on mediation as parties with the pandemic want recovery rather than an award or a judgment which they can then paste on the wall. There is also a greater willingness to have a matter resolved through a virtual hearing. Traditionally speaking, litigators, I mean, speaking for myself, I like to stare at the eyeball when I'm asking a question. You don't need to do that. The virtual hearings has taught us that it is still possible to have an effective process, quick way to resolve disputes without troubling people to fly and sit in the same room. That's my experience with virtual hearings.
It's been very interesting in this current period, sitting as an arbitrator, even when the legal teams for both sides are in the same city as I am, even then they're suggesting we do everything virtually, particularly if they've got clients who are overseas and will just testify from a video connection. It all seems very smooth nowadays, and in fact it's almost the default expectation. I must say, in the context of mediation, I have one very large case on which involves 3 or 4 different jurisdictions. There was no chance in COVID that we would get everybody together, and the immediate assumption was that mediation was no longer possible. But I spoke to a very experienced international mediator who said that he was achieving better conciliation results in mediation events on virtual settings than he had been in person. He's a very hands-on style of mediator. I was very surprised. But he said that people are more relaxed in their own setting, and so they're more willing to share information or engage in conciliation. And he also said that he was able to get all of the stakeholders in at one time, whereas previously to get the CEO to fly somewhere to conduct an all-day mediation was very challenging.
And maybe you can talk a little bit about the combination of arbitration and mediation.
So my experience is, where there is a dispute, there is a need to initiate an arbitration because parties may not want to speak to each other yet without testing the relative merits. It's a question of timing, isn't it? So an arbitration does not necessarily mean that's the end of the relationship. So an up met up clause is a perfect example of how parties can initiate arbitration, trigger a mediation, attempt a serious attempt to settle the matter, and if that doesn't work, continue with the arbitration.
I think another aspect of the financial distress that's been brought on by the COVID period is clients are very cost conscious, and if there's an opportunity, even after they get into the dispute process, to short circuit that by coming to a negotiated solution, I think many parties are open to that. So a combination of the mediation and arbitration options, or even just without prejudice negotiations, is still very attractive, certainly.
How did companies learn from COVID-19? And how can they protect themselves in the future?
The pandemic has led to a business failure. And a business failure, speaking legally, does not lead to the non-performance of a contract. Parties would still need to perform their part, even though practically speaking, they may not be able to perform. So there was a sharp focus, what lawyers call force majeure. It's a contractual term which would allow a party to not perform its bargain, or at least suspend its need to perform that bargain. There have been instances where I was involved in where there was that urge to invoke force majeure. But looking at the circumstances, it was not sufficient enough to trigger that common law concept unless it was contractually provided for. In terms of specific terms, as lawyers know, force majeure, you need to provide it as precise as possibly can in order for one to rely on it. So my experience is that the terms which exist now is not adequate enough to cover the COVID pandemic.
Certainly, we see clients in the booming M&A environment that we now find in this region. Clients are much more focused on that clause, on force majeure, or some other clause which deals with suspension of obligations. And of course, one issue is whether or not it covers even pandemic risk. And now, in new deals that are being done, it's essential that clients consider whether or not they need to make a specific provision for potential further impacts of COVID. So there is a lot more attention to that clause, I think, in the negotiation process. There is also, I think, a need for parties to be sensitive to the context in which their clause will be interpreted, and by that I mean maybe the tribunal or either the arbitral tribunal or the mediator or the judge who will review the contract, but even the other side in terms of what their unexpressed expectations may be about how such a situation would be handled. And I'm aware that in the civil law context, and I've had occasion to enforce common law contracts in front of civil law tribunals, there is actually a strong expectation that the judge or tribunal can participate in rewording the obligations if there's a real difficulty of performance which arises unexpectedly after the signing of the contract. As Bazul and I experienced, I mean, that's not available in common law, and ensuring that both parties appreciate how those clauses will play out in the real world if something goes wrong is extremely important at the time of doing the deal, so that they are transparent and clear about their expectations, and ideally write them down so that they can be dealt with if something were to happen.
So how one should look at the common law and civil law distinction, just hearing Jelita, is look into the philosophy, the psychological reasons for that distinction. In the common law, the judge or the arbitrator is to play the referee. Party autonomy is key. You guys went into the contract, you made the deal, you have laid your bait, or you made your bait, you need to lie on it. The judge is not going to interfere. So civil law, there is that room to say, hey, that's unfair. I am going to participate in this game and rewrite that bargain. That's not allowed in the common law.
No, I think that's so valuable for the audience because it doesn't come automatically to many of us to really have that distinction in mind between common law and civil law. So if I may ask the last question here, which is, as we emerge from a post-pandemic world, what is one piece of advice you would give to companies? Maybe I'll start with Jelita.
Wee Meng, I'm going to ask you to indulge me and let me say two pieces of advice. One is more of a warning. I have seen, unfortunately, in some of these situations where, quite rightly, parties are prepared to allow time on the other side to recover, to perform, to postpone obligations. Unfortunately, I have seen some situations where later, when the party wants to press ahead with some kind of enforcement or claim, they may have lost some of their rights through a failure to issue the right notices under the contract at the relevant point in time. So my small warning is for companies to just be aware and be mindful that although negotiation is certainly recommended, they should also just make sure they are preserving their rights along the way. And then maybe the nice one is just to think about business in the current environment. We're just beginning to move around again now. Everybody has become more used to dealing with one another virtually, and that's certainly positive. And one way of keeping in touch when you can't have those in-person meetings, we've enjoyed sending and receiving gifts in our practice, where as long as it's within the bounds of your bribery compliance policies, if it's a small gift, a token, that can be a nice way to share a cross-border culture at a time when we maybe can't be traveling to one another as often as we used to.
So I think we need to be more adept in using technology. I don't think we need to wait until we get that opportunity to get on a plane and fly and have a physical meeting. By then, unfortunately, much may have gone under and parties may not even be prepared to have that physical meeting. So I think while the problems are festering, what one should do is get on the Zoom. Now we are all familiar with Zoom. Get on the Zoom and see whether we can resolve that particular problem before it becomes uglier. That's what I would advise.
Thank you. Those are really good advice. If I may add one advice is to get good counsel. So with that, I would like to thank Jelita and I thank Bazul for joining us for this session. Thank you very much for your time and I hope that has been helpful for all of you. Thank you.